Paldies. Labrīt vēlreiz, dāmas un kungi.
Good morning, ladies and gentlemen. I would actually say that more so of ladies. I see much more ladies in the hall than gentlemen, but in any case, if you're still having coffee, you feel free to bring it with you to your seat. We have a very busy day planned. I hope that it will also be very productive. My name is Aivis Ceriņš, and coming to this conference, I asked myself, is data protection an important issue for me personally? And I came to the conclusion that yes, it is. And why so? Because I wouldn't want my personal data or sensitive information about my health or so forth to be accessible to people that would want to use it for sort of negative purposes. So do I want companies in Latvia to invest in data protection for me as the final consumer to be also charged for this? Because obviously you have to invest your time and your money to provide this protection. So my conclusion in the end was that today's conference and these lengthy discussions will all be with the purpose to maximize your efficiency, to minimize the investments in time and money that you have to do in order to provide adequate data protection. So once again, welcome. And before we start off, I'd like to start with a little icebreaker, a tradition that I've set up in my family. Before we begin the day's event, look for someone next to you or behind you or in front of you. Look them in the eye and tell them, have a good day. See, you're all smiling now. It's so easy, and it's not much that we have to do to make a good day for all of us. So to open the conference, I now ask Mr. Raivis Kronbergs, the State Secretary of the Ministry of Justice. Please, you have the floor. Good morning, honorable participants of the conference, cooperation partners, guests. I am proud that this is our second largest conference in Latvia, dedicated extensively to the data protection matter. And this is an important issue in our lives in modern society. The first conference took place in May of 2018, when we were training everyone and explaining how to actually work with the GDPR rules. But today, we will discuss the responsibility of SMEs and also the opportunities available to them. The year and a half since the implementation of the GDPR has been very busy and eventful for both you as entrepreneurs as well as for society as a whole and for the Ministry of Justice as well. The implementation of the regulation was symbolic in the fact that, as the Data State Inspectorate has said, they hope that this conference will bring better understanding of why it is important to protect data and also improve your understanding of the importance of your personal data protection for you as individuals. The speed of life nowadays makes us seek new solutions. We are facing new challenges. We have to seek new ways of working, and we cannot rest on what we have achieved so far. The smart technologies that we use nowadays in our daily life provide us communication opportunities to communicate with our friends and family throughout the world, and it's also given us an understanding of how important data protection is in terms of our private lives. Personal data protection is nothing new, neither in Latvia nor in the world. It's simply that each and every one of us have to approach our actions critically. We have to take care to ensure that our data is protected. We have to work together with our data controller, our data protection specialist, and the data protection institutions. It is definitely a big challenge because data is a value that is owned by each individual. Data is an opportunity to obtain better services and simplify the development of various technological innovations. Data is a resource that allows entrepreneurs to organize their work most efficiently and to provide better products and services. In turn, the regulation is a guide for the best possible transparency between the data collector and the data owner. I'd like to urge you to work together to improve people's trust in data protection so that our services and innovations can provide an input in the general development of our national economy. And in conclusion, I'd like to quote our wonderful national poet who said that he who changes shall survive. I hope that what you hear today at the conference will be a good beginning step for your further work with data protection. Thank you, and I wish you a fruitful conference. Thank you very much for coming to join us. We would like to present you with a gift and say thank you. We, of course, have gifts also for Secretary of State. Doesn't matter who you are. So this year has been marked by the fact that the way we communicate has changed. We know that our regional minister, Mr. Pūte, has gone on a tour around the country. We've also had a very busy tour done by the Data State Inspectorate, who wanted to educate and everyone throughout the regions with the data protection regulation and the rules. So now I will give the floor to Ms. Daiga Avjanova, the director of the Data State Inspectorate of Latvia. Good morning. I'm very happy to see you all here today. Last year, on 25th of May, we had perhaps a bit more guests in our conference, but I see that still today the interest has not waned in the GDPR. So I would like to look back on what we have achieved over the past year and a half. And what I'd also like to note about this conference, why we are holding it and what the road has been to this conference. A couple of years ago, we had this crazy idea that we should inform entrepreneurs and society in general about the rules contained in the GDPR. The regulation had taken effect, but it wasn't being implemented yet. We had to prepare for the implementation, but we understood that our budget was limited, and so we tried to figure out what we could do. That we needed to inform people, but how could we do it? And then we heard that the European Commission has this option available that if we craft a good enough project, we could finance this information campaign. I saw this opportunity and I said that we should go for it. My colleagues were a bit skeptical because they said that our human resources aren't very extensive. We were about 20 people at the time, but I said that we can definitely do it. We surely can. And today I see that we have succeeded, we have done it, and I'm very happy to see this. And I'm very proud of what we've managed to do. And I'd also like to thank the project team, first and foremost our project leader, Anda Berhan. I won't ask you to come up front, although I would definitely want to, although she asked me not to do this. Likewise, Agita Silniece, who tirelessly followed through with what we have to do on the project and informed us all on the steps that need to be taken. Thank you to her for her tireless supervision of our actions in the project. Also, thank you to Lars Medilbe, my deputy. Thank you for the supervisory work and not stopping at what we had achieved and going forward. And also a great big thank you to my former colleague from the Ministry of Justice, Dace Purinje, who wasn't able to join us today, but she helped us with all of our ideas, and she generated new ideas, the same as Mr. Lauris Linebergs, who many of you know, and he's known not only in Latvia, but also elsewhere in Europe and in other data protection agencies throughout the member states. So thank you to Lauris for his ideas. And the next stage of our project will be informing and educating students and school children from ages 13 to 17. And our unique idea, which emerged during the preparation of our project, we're going to Google, and we're taking children with us as well to show them how it all works. So this is a big idea that we will implement. But perhaps a step back and to say a few words about the emotions and the emotional aspect of this project. But I just wanted to thank everyone who was involved in the implementation of the project. So moving on, regarding the implementation of the GDPR in Latvia, we all know that the law on the protection of natural person data has been adopted in Latvia. It took force in July of last year, and the administrative burden has been reduced so that now personal data processing is no longer registered at the data inspectorate, but regardless, we are often asked, why are these things not supposed to be registered anymore? People want to bring in their, for example, video cameras and register them, but they no longer require registration. So prior to beginning our project to inform SMEs, the research center SKDS carried out a survey which found that 92% of entrepreneurs have heard about the GDPR and only 8% have no idea what the GDPR is or have never heard about it. The good news is that 48%, so that's almost half of entrepreneurs have ensured compliance with the requirements of the regulation. 34% say that they still have some work to do to fully comply with all of the requirements, and only 13% said that they have done nothing in this regard. 80% of entrepreneurs who took part in the survey said that they know what the legal foundation is for the personal data processing that they do, and only 15% don't know. But that's why we're here, that's why we're supplying explanations, why we will explain the legal foundations throughout the day today. And I think that this percentage will approach zero in the near future. At least that is our goal, and we are moving towards it. What are the obstacles found in the survey as identified by entrepreneurs? We've identified problems with data processing for customer and cooperation partner data, information storage and processing technologies, staff data. This was indicated by 11%, and with problems with other databases were indicated by 6%. 76% of entrepreneurs provide the opportunity to revoke consent or not give consent for personal data processing. However, 20% do not offer such an opt-out. 75% of entrepreneurs inform data subjects about their data processing, whereas 18% do not do this. These were the results of the survey. However, the results of our controls show that this percentage is, however, higher. The percentage of the companies that do not inform data subjects about their data processing. However, this again is something that we want to reevaluate again next year, and we will be able to come back with the new data next year. So what are the issues that are of interest to companies and entrepreneurs that have been raised with us? So one of the questions is, what does it mean that data subjects have the right to be forgotten? This has been asked by 54% of the entrepreneurs. In what cases can a company provide data, personal data, to third parties? 53%. And in what cases can personal data be processed without consent? That's 53% that have asked this.
A very good indicator, and in fact, it's a Eurobarometer study that shows that we in Latvia have really done a huge job to inform about personal data processing, because more than 70% of companies know what supervisory authority is, and only 23% actually have not been informed about supervisory authority. And this is really the outcome of the work that we have done in the previous years, awareness-raising measures, providing advice, also giving presentations at seminars and conferences, and also providing advice over phone and also interviews. Now the results that we have, 2018 and 2019. As we see, the number of complaints also this year actually is reaching approximately the same level as in the previous year, or more than 1,200 complaints. But the content is much more complicated this year, and the inspections that we carry out are more complex. Also, when we have such inspections on the basis of complaints, then the scope of our work is equal to the previous year. And I estimate that at the end of the year, this number will be over 300. And this year, we have adopted 40 decisions in 12 cases. Well, these are the data on the first 10 months of the year. And in 12 cases, we have applied some sanctions, monetary fine in 7 cases and warning in 5 cases. Now, the scope, the range of the monetary fines that we have applied. Last year, that was from 70 to 2,000 euros. This year, on the date on the 1st of November, the amount of monetary fine was between 300 and 7,000 euros. And in November, we applied a sanction to one company, which is the largest monetary fine until now. That's 150,000 euros. This data and this decision will be made publicly available quite soon. And also, society will be informed about the infringements and violations were identified. Actually, these violations were not ensuring accountability and transparency. In applying these fines, we have taken into account the criteria defined in the regulation, so the fines that we have applied do not reach the amount, the level that they reach in other EU member states. And we will have our colleagues talking about their experience. And I hope that they will tell and reveal why have reached the sums of money, the amounts of fines that they are applying, and that this will be important for us, and we will understand whether it's important or not to apply such fines in some cases. Because, as you all know, one of the requirements of the regulation is a consistent application of fines throughout the EU member states. And so we have also to follow the example, the model of other EU supervisory authorities. And in 2017, memorandum was signed, and we introduced the principle consultations before, or provide advice before, and we have applied this principle in 32 cases, and we have sent invitations or letters to companies asking them to abide by the requirements of the regulation. In 2019, this number has increased, and we have applied this principle already in 174 cases. Now, the statistical data with respect to notification on personal data protection violations to supervisory institutions. Last year, we received notification in 46 cases, and in 2019, 10 months of 2019, we have been notified in 94 cases. In some instances, we have also conducted inspections, and we had identified very serious risks to the rights and fundamental freedoms of data subjects. And we have pointed out this to the companies, also to institutions of public administration, that data subjects should be informed also about these violations of data protection rules. Of course, we also had to introduce the principle of one-stop shop. And in this area, we are working with the resources that we have, and I am convinced that in taking into account increase of funding, and also next year, and taking into account this international cooperations that we expand, and also our cooperation with other supervisory authorities will be expanded, and all this cooperation will be more meaningful. Currently, we are working on 2 decisions, drafting 2 decisions to introduce this principle of one-stop shop. Now about consultations over phone, face-to-face, and written. Here again you see statistics, and you see that both companies and residents are highly informed about this. As you see last year, the advice that we provided had been very much in demand. And this year, this need to receive advice over phone or face-to-face advice, this need has decreased. And this is a very good indicator. I believe that also in the future, we will continue this work. Although the numbers are decreasing, but compliance with the requirements of regulation will be ensured, and we are going to increase awareness of these requirements. This conference is also the concluding final event of a series of 10 seminars that were organized previously in various cities and regions. We have visited and informed companies in Ventspils, Valmiera, Cēsis, Riga, Jelgava, Liepāja, Jēkabpils, Ludza, Daugavpils. And about the findings that we have made from these seminars, you will be informed about Agnes Babovica, who is co-chairman of the Latvian Association of Certified Personal Data Protection Specialists. I'm very grateful to you for your cooperation, for the questions that you have addressed to us. I really feel satisfied, and I'm very happy that we are holding this conference. And we will have also the second stage of this project. Perhaps we won't meet some of you, but perhaps you will also be welcomed during the second stage of our project. So thank you once again, and I hope that this conference and this whole day will be very successful to you. Thank you. It's so nice that the bosses are doing the job instead of employees. As Madam Avdeyanova mentioned already, the next speaker coming on to the stage and speak about awareness of SMEs and the findings of these 10 seminars and will guideline in data processing. Is Agnes Babovic, a representative of limited liability company, data protection, and also represents the Latvian Association of Certified Personal Data Protection Specialists. Good morning, indeed. I had the honor to be involved in this project. I was a lecturer, speaker. I visited regions of Latvia. And the one thing I have to say immediately, really, I have traveled throughout Latvia. I know each and every corner of it. During this project, I had to conduct seminars almost every week. On Tuesday in Ventspils and on Thursday already in Jēkabpils, so I was traveling throughout the country. But I am indeed very happy to see so many of you here, because this also outlines the positive trends that we observed also in seminars. This was not like coming and going in waves, that people were really worried only about the regulation on the 25th of May last year. But this is a document that we consider in our daily operations. At the very beginning, I'd like to make a reference also to Margaret Westhagen's statement in Data Protection Congress that was held last week. She's not only commissioner who is responsible for competition issues, but also digital market and data protection issues. And in her speech, she noted that we often hear that data is the new oil, but the metaphor is not 100% correct because data are much more valuable than oil. They define what we have been, what we are, what we want to be. And control over data is a very important part of personal liberty. Historically, a person has had the freedom to decide what kind of information and to whom to provide. I believe that with adoption and implementation of the regulation, and of course this implementation is ongoing, but by this, the digital slavery has been abolished. Any person, anyone of us can only not grumble that I'm dissatisfied, I don't want my data to be treated like this, but we have all been given a tool how to defend our freedom, our liberty. And in my seminars, I have often noted, this day, you came here as representatives of SMEs. You are like the delegate. You've come because your employer has sent you. Perhaps you are an employer. But while listening to me today, always remember that you have two hats. On the one hand, you have your obligations that the regulation imposes on you. But on the other hand, you are also a data subject who has rights. And at the time, when you prepare some kind of documents, when you look at the way how to develop your business, don't forget about yourself as a data subject, so that you should understand what you've written, really. So this abolition of digital slavery, perhaps, well, this seems to be perhaps too harsh a statement. However, while preparing for this seminar, I looked into Wikipedia. The abolition of ordinary slavery took many centuries. We are only at the very beginning of the past to understand, to be aware what is honest, what the regulation wanted to achieve. And we saw this also in the framework of the project. So when we were holding these seminars, later on it was quite interesting to read your evaluation forms and your sometimes people, the participants were saying this was all too theoretical, I didn't understand a thing, to a few examples. Then I take another form, everything has been quite clear. Also, examples from practice, I'm going to use this in real life. And when we were preparing for the next seminar, we couldn't understand where the problem was. One participant had understood everything, the other had understood nothing. But perhaps the answer was not to be found in the content of the seminar or the complexity of the regulation. But if we speak in analogies, I assume that we all have the feeling that we should not support slavery. And then most probably those who were saying that everything was clear to them and the seminar had succeeded, that they had been given this feeling, what is fair, what is not fair, and that the data should be processed in a fair manner, so that we shouldn't be ashamed and we shouldn't be afraid of the State Data Inspectorate.
And so we had the feeling that this dissatisfaction with our seminars was mostly with those people that didn't sort of get this checklist of what they have to do so that the Data State Inspectorate is happy with me, forgetting that the regulation is actually a very good guideline for protecting not only personal data, but also protecting your company, your commercial information, and ensuring that your company survives both today, tomorrow, and the day after that. The interesting elements that I could also mention in regard to this understanding, this awareness, our director already noted the survey that was carried out, and just a sort of comic side note, there was a seminar in which I spoke about my experience, saying that this is a process. It's not a road finished. We have to think about these issues on a daily basis. Beginning a new project, we have to think about these issues. And as I said, and I noted my experience, saying that I've have over 10 years of experience, and unfortunately I've never seen a company that is 100% compliant with all data protection rules. And then on these survey sheets, people said that, well, there's no use trying if you can't fulfill all of the requirements anyways. But that is definitely not the case. It is a process. It's a work in process. It's never ending. And I can promise you, and I see that there's so many of you here today, that if you set up a privacy policy on May 25th, you know that you had to already update it several times to ensure that it is compliant and correct and up to date. Now, speaking about this, these feelings that some people had after the seminar, I'd also like to note that the survey found that 80% of entrepreneurs said what the legal justification is for data processing. They know how to use it, and that their employees know about this, and everyone knows everything. But then there was another issue that companies wanted to find out more about, which was 53%, when to use consent. So if 53% are not sure about the actual implementation of legal justification in one situation or another, and at the same time 80% say that they are completely aware of all of the rules. So perhaps this is not quite the case. I don't want to be overly pessimistic, but what I want to urge you, and what I want you to take away from this, is that this is a never-ending process. And I'm happy to see you here today, that you're willing to take part in this process, because I think that our foreign guests will be able to provide us with very interesting insights that will definitely be beneficial for us going back home to improve our own processes, and so also to improve our own understanding of what data processing is, rather than just sort of put a little tick on a checkbox to make the data state inspector happy. So let us all have a very productive and constructive day. So thank you as well for the tour and the seminars that you provided. Thank you from Ludza and all the other regional cities that you visited. I will now give So moving on, this was just the introduction or a short prologue. We are now actually ready to get down to business. So the people standing up at the end of the hall, do take a seat. We have plenty of empty seats here at the front, so don't be shy. Ladies and gentlemen, I'd like to inform you that after the discussions, after the lectures that we have set up in two blocks, the first one being the foundations of the regulation, and after lunch we will look at the responsibility of the controller. But after each of these sections we will have a short panel discussion, and you're all urged to take part by sending in your questions. If we can just bring up the QR code on the screen that you should use, or actually the access code that you should use rather. So if you have a question about the topics that we are discussing, do use this link, www.slido.com, and use the ID code hashtag U291. We will receive all of your questions, and I will try to use as many of them as we can during the discussion. If there are a lot of questions, I already apologize for not being able to use all of them. But in any case, We will now give the floor to a person that all of you already have know very well and that has gained recognition throughout the EU. This person being Mr. Lauris Linebergs, head of the registration department of the Data State Inspectorate of Latvia. He will tell us about the scope of the GDPR automatic data processing filing system, data concerning legal persons, and processing of legal persons' data, data processing and household activities. Hello, I am happy to see so many of you here today. I think that my recognizability is greatly overrated. I'm not sure that all of you here know who I am, much less would the European Union know who I am. But regardless of that, as the representative of the Data State Inspectorate, I am here to tell you about the scope of the GDPR. So the scope is included in the article so-and-so of the regulation. You can just read it and we're done here. But if you're here, you know that you've already read these articles. If you've attended the seminars, you've heard the interpretations of these articles. So I will take my time given for me today here to sort of discuss about this scope so as to provide you with a better understanding of the idea behind it and sort of to explain my understanding of the goal, of the objective and scope of the regulation. Now, of course, the main focus of the regulation is and will be the large automatic systems of processing systems. But it is more difficult to define what a large automated data processing system is. The previous regulation was adopted prior to the big data actually appearing and being used. So the rules of that regulation were applicable basically just to the global internet users. At the time of the previous regulation, the number of internet users were about 16 million. Now it's 4 billion. And nowadays we have so many smart technologies and smartphones in the hands of everyone. So what we thought was a big data processing system in the 90s is basically in the hands of any user today. What was a processing system in 1995 is a system that any school child uses to make their homework at night at home. So this means that each and every one of you SMEs and micro companies have at your disposal resources to process huge amounts of information to provide better products to your consumers, to your customers, to ensure your competitiveness, while at the same time respecting each other. As they said in Star Wars, if I'm not mistaken, great power comes with great responsibility. So the same applies to data processing. We are able to learn more about a person or a customer, perhaps learn more about them than they know about themselves. So why automated processing? Why digital environment? Why are these the focuses? Because it's huge amounts of information that can be processed quickly, rapidly. If we remember the traditional filing systems, we had to take these large binders and flip through them and spend half a day to just set up a single file for a single customer. Nowadays, it's just the press of a key and we already have the file on our screen within a matter of seconds. So that is the reason why this automated data processing carries with it the much larger potential risks for various problems. So one of the prerequisites that we have to consider is the ability to find information in the data flow at our disposal. If we cannot find the data, does the regulation apply to it? This is, however, a very risky or a slippery slope to take, because then we have to be sure that we will not be able to find any information in our systems. So if a person tells us that they want to be forgotten, and we tell them, yes, you have been forgotten, but we deleted this data from one computer, but the other computer wasn't connected to the network, and the data is still on that computer, and one of our employees sends a new email to that person. So will that person be able to trust our company? Because in effect, we lied to them. And the impact on our company's reputation will actually be the greater loss here. The fact that the person will go to the data state inspector and say that they exercised their right, and then the company didn't do what they were supposed to, and even sent an email afterwards. But in any case, the main loss here will be the loss of our reputation. And so as to avoid such situations, such accidents, do take care to supervise, manage your internal systems, take care about the information that you process, structure it, because that will simplify not only compliance with the requirements of the regulation, it will also make your own work more efficient. It'll let you understand the internal processes of your company better, and it will in turn let you make a better profit. As regards identification, I found a funny photo here to share with you. But we're not speaking about personal data here. Obviously, we see these emojis on top of people's faces in the photo. But I thought about it, and actually, people would be able to identify themselves and others from this picture even with the faces blocked out. For example, if I was the person in the gray hoodie, I could write to the author of the picture and say that, well, you put a sad smiley on top of my face, and now all of my friends are making fun of me for this. Please delete this photo or delete me from that photo. So if a person approaches us saying that they can still identify themselves from the mass, even in an anonymized photo, for example, we still have to act. So our mantra should be that if we can identify an individual from a broader group of people, then the regulation will apply to this data processing, and we should apply greater care to this data, because obviously we want to keep our clients, we want our clients to trust us. As has been said on a a court case related to Latvia, we have to understand each other. We have to understand that personal data is everywhere. And what I already mentioned, the main focus is on data processing in the big automated systems, but in communication between two individuals, data processing rules should be applied less strictly. We should apply common sense so as not to dive too deeply into a very strict interpretation. So as regards communication with our data subjects, our customers, we should abide by common sense and mutual respect. We should understand that as entrepreneurs, we have to be ready to adapt. We have to be ready to adapt not only if the data subject has found an identifying element that we have not thought about and have identified themselves in the system, we have to be ready to adapt. If there's a technological innovation that we haven't seen before, that we haven't thought about before, we have to adapt to that as well. I urge you to, instead of seeking out ways to sort of bypass the legislation, as this is something that is quite common in our sort of cultural space, but we should not try to seek out loopholes. What we should do is look at this piece of legislation as a tool that allows you to work in a broader space, in a larger space, to provide your products and services not only in Latvia but throughout the EU. This is a tool allowing you to ensure that your data is protected, that it's safe, and that you have the option to show your customers how trustworthy you are, to thus promote your mutual dialogue.
I was just now focusing on automated data processing. Perhaps some one of you might feel tempted. Let's just delete everything out of computer. Let's move back to paper, put client information in the file, and this we are going to give to the accountant before going into state revenue system. This would not work. Any file would be subject to the regulation. So this temptation to stop progress, to stop processing information digitally, you should not follow it. Now I'm jumping on to the next question. Shedding papers. Well, my main idea is the following. When you process information, data processing should not be the main motive, as I have said already during previous seminars. Well, data protection should be a constant background process. It should not be an aim in itself for the company. If you have some mechanisms, you have the aim to make profit, you have to prepare offer. Your objective is to do everything that I, not being an entrepreneur, do not understand fully. But the whole idea is that these principles of data protection should be applied to that information that you have at your disposal, so that you would be able to reach your aims, respecting human rights, also respecting the rights of your clients, respecting business logics, and finally ensuring that your commercial information, your business information, things that you don't want to say to third persons would not end up with third parties. It's not so important. Let's say we are a restaurant, we have a very good chef, and everyone else wants to tempt him to their restaurants, and we want to protect this information. And well, we have to protect the information because these are personal data, but also this is information that would directly influence our business activity. So we reach two aims, two objectives. Well, we might be tempted just to throw out some kind of documents that we receive. Let's not make a file. Let's just throw this into rubbish. What kind of impact this could leave on our reputation, that we have thrown out some kind of correspondence with a client without hiding it, I don't think that the clients will want to send anything to us, and partners of cooperation will also reconsider possibilities of continuing cooperation with us. So how to achieve this compliance? So that you would have good client relationships, good relationships with your partners of cooperation. And I believe the data protection principles serve as a very good guidelines for you if we really follow it. very strictly, we all understood that the very logics of the law comprises the steps. While these might be 8 or 12 steps, the number is not decisive. But we will understand that our processing is fair, that we obtain only that information that is needed for to reach the aim of processing. We are not storing it for longer than necessary after achieving this objective. And we are going to process this information in a way that prevents other persons from obtaining this information. So we should do it legally and safety. And of course, if we've had to adjust some systems because of implementation of the regulation, but we should perhaps say thank you to the regulations. That meant that our systems needed updating, and now the systems allow us to work in a more transparent and safer way. But I have deviated slightly from my topic, the scope of the regulation. And here we'll come to the most controversial part of my presentation. Well, speaking about part of a larger mechanism, just one of those clogs, then applicability of the regulation will be smaller in scope. If we talk about Lauris Linebergs, the head of registration department, representative of the State Data Inspectorate. Okay, now we process Lineberg's data, but if we process this data to get in touch with this registration department, this will be more like processing the data of my institution. If we send to Mr. Linebergs a letter stating that new windows are being sold, then my data will be processed as data of a natural person. If I receive some kind of offer by a political party or pharmacy, this will not apply to the institution in any way, to my professional activities, in no way. But until we have some communication about our professional public ego, and it's used in the framework of our professional life, in this case, the scope of data protection could be much smaller. And so we have we have to look at the professional life and the private life and identify the purpose of processing. And if we process this information in view of the scope of processing, we might also find certain logics in our activities. This picture perhaps serves as a better illustration of this. Here we have a street. Let's say this is a symbol of our public professional life, our daily life. And you see apartments here along the street, and this illustrates our private part, our private zone, which is separated from our daily activities. And the scope of application of the regulation could be found also in this public area, but this will be much smaller compared to our attempts to look through the windows and understand what's going on in the private space. We should be really focusing on public data processing. The regulation is not prohibiting anything. If we can provide justification, we will be able to process information in any other form as well. However, if we move into that space which is behind the windows, behind the doors, then our justification and grounds will be much harder to find, and we will be engaging in a risky game. Another important aspect which should be taken into account, and what I wanted to talk on, these are personal and household needs. Well, entrepreneurs won't have personal or household needs. Any data processing that we engage in as a company, to this processing, this exemption will not apply. But as Agnes mentioned, we all present here, irrespectively of the roles that we have, we are also private persons, natural persons. And we have to understand what we can do with information ourselves without entering the scope of the regulation. And I believe this is already the 18th recital of the regulation dealing with social networking, which is outside the regulation. And again, it seems to be even in a way a philosophical term or decision. So these are reasonable expectations with respect to protection of privacy. At what moment and to what extent we can reasonably assume that our privacy is being protected? If we walk down the street, then our reasonable expectation with respect to protection of privacy cannot be very high. We understand that this is a public space. We understand that we are seen by others. If we are in our private garden, then reasonable expectations with respect to our privacy are much higher. And in that place, we can and we should demand respect from others. Now about the material, this scope, I said a lot about that, territorial scope. Well, territorial scope won't be that important for the group of SMEs. It's important to understand that the impact of the regulation is going to be global, not only directly as being applicable to companies working outside the framework of regulation, indirectly promoting better and safe protection framework for protection of personal data, because we know that in many countries now these new data protection laws are being drafted. But we have to understand that this regulation will be applicable to us because we work in the EU, and also because we work with the data of EU member states. The regulation will not be applicable to this, contrary to some caricatures that we saw last year where we saw cemeteries. No, this regulation is not applicable to deceased persons. Only private persons, living private persons, are within the scope. And the information about legal persons is not included in the regulation, even if the name and the address of the legal person and the private person might be similar. If we process it with the purpose of processing information of legal persons, and according to Article 14, this should be outside the scope of regulation. But we should always be interpreting this on the basis of the initial objective of processing. And of course, the regulation is not applicable if we are not processing personal data. If we have a set of information which cannot be applied to identified person or persons that could be identified, then we are not applying regulation to this. If we are not processing data within the EU, but I believe that all of us present here as who process data probably will be doing this here. And other exemptions will be more interesting for the public sector, like which do not fall within the scope of EU legal acts. This is security, which is then done by competent authorities. Well, that was all I wanted to say. Thank you. Thank you for your attention. Laura, I would like to thank also you. Thank you for your time and for the excellent job. Then, ladies and gentlemen, the speaker was Lauris Linebergs. But now all of you know him. That's for sure. Anyone who doesn't know him. Excellent. I would like now to ask those speakers who have already spoken not to leave us, because after 3 presentations we are going to have panel discussion. Even if you've gone somewhere far away to get your coffee, we'll try to call you back. Now, the next speaker will be Certified Data Protection Officer, Senior Associate at KPMG Law Latvia, Sanita Petersone, and she will be telling us about the principles of personal data processing. Let's welcome Sanita Petersone. Hello. I have this possibility to tell you about data processing principles. I'm Sanita Peterson. I've been involved in data processing for more than 10 years already, and I've understood that we really have this challenge in front of us to introduce these requirements and to achieve compliance. But this is doable. You just have to persist. But to understand how to do that, it's important to understand the principles of data processing. Perhaps some of you think we do know those principles, but it's always worth recalling them. And some things that we have understood as consultants, companies come to us and ask, could you give us some kind of certificate that we have done everything and we are compliant with the regulation. We go to the company and conduct an audit, and we understand that even the basic principles have not been understood correctly. Some things have been done that are not required by the regulation, and other things that are mandatory have not been done. So it's always worth recalling these main principles, because this is a very cornerstone and the guiding light for us, so that we would introduce the requirements effectively, and we should not spend resources where this is not required. And now about the principles. Well, the very substance of the principles. Here we have to turn to the regulation itself. The principles have been defined in Article 5 of the regulation, and then they are interpreted in greater detail in Article 6 and 13 of the regulation. And I will speak about the very substance of the principles, and the speakers afterwards will be speaking about particular principles. My task is just to outline the broad idea of these principles, just like it's done by Article 5 of the regulation.
If we ask, how should we implement these principles? This will require organizational processes by setting up our internal and external procedures, our policies. We will also require legal knowledge, legal processes to select the proper legal basis, and of course also technical solutions which will ensure safety of the data, such as encoding and access rights. So these are organizational, technical, and legal measures that we need to apply to ensure compliance with these principles. All of these principles are equally important. We cannot forget about one, saying that, well, we are already compliant with the data safety, we're encoding all of our data, so we don't have to pay attention to the legal basis or consent. We have to respect each principle equally. All of them are equally important. All of them have to be applied simultaneously to data processing. So who has to comply with these principles? Well, it's easy to say that all SMEs have to comply with these principles, because all SMEs perform data processing, but the extent of which this data processing takes place and the extent to which we have to comply with these principles has to be evaluated on an individual basis, because it depends on whether we are a controller or we are also a processor. And to answer the question, why do we have to comply with these principles? I like that previous speakers already highlighted that we have to not only be fearful of fines, but we also have to take care of our reputation, because people are more and more involved in their data protection. They are demanding more from companies, and they are giving more respect and more business to the companies that respect their personal data. And through these processes, we can also safeguard our commercial secrets. So all of these should be our motivating factors for us to comply with data protection rules. As I said before, it is very important to understand the role of our company in data processing. I can say for sure that each and every company is a controller in data processing in regard to their staff data, their customer data. You are a controller, so you have to comply with all of the aforementioned principles. If, as a company, we provide services to other companies and we obtain from these other companies information about their customers or their staff members, and we act on behalf of other companies by storing the data owned by other companies on our databases, for example, servicing accounting programs and so forth. If we send out invoices on behalf of other companies, then we are also a processor of data. And we have, therefore, this role of processor, and we have other specifics within the principles that we have to abide by, and the principles that we have to abide by as processors, not only as controllers. So it is very important to identify the specific role that our company has, because each and every one of us uses some kind of service providers. We provide data to these cooperation partners, and we have to understand what our role is and what their role is to know that whether you are a controller or you are also a processor. So the identification of your role is the prerequisite to understand the principles by which you have to abide by. Then, speaking about the principles in essence, first of all, we have fairness and trustworthiness as an idea. This means that when we process the data of our customers or our staff members, we simply have to remind ourselves that we too are a data subject, and we have to think about how we would feel if our data was processed in the manner that we are about to process other people's data. So what would our feelings be in that specific situation? Next, the legal basis, which we will discuss in more detail later on. But just briefly, I'd like to highlight that the cases set out in the regulation for the legal basis show that consent is not required for all types of processing. Consent is required for specific processes, and unfortunately, I think that the regulation has sort of shot itself in the foot by providing this misrepresentation that many companies think that they have to require consent from each and every one of their customers, and then they will have complied with the regulation. But by choosing consent as the legal basis for absolutely all of your actions is already in a breach of the rules of regulation, because in many cases you cannot even use consent as such. Because, for example, for employers, there are only a handful of cases in which consent can be required, and we have to look to other legal acts that provide this legal basis. For example, even if a state institution asks us for personal data, we have to look for the legal basis whether we actually are allowed to provide this institution with this data. So that would be an introduction about the principles. Then the next idea that we have to talk about is informing data subjects. So if, as I already said, consent is required in only a handful of cases, then data subjects need to be informed about their data processing in absolutely all cases, irregardless of whether their consent is asked for or not. But they have to be informed in absolutely all cases. We cannot perform covert videotaping. We cannot record a conference without informing all of the participants of the conference or of the meeting. That is with the goal of making sure that all people who provide their data are sure and they understand that this data will be used. So if you want to take part in a lottery, you need to know where your data will end up, what company will process your data, and only based on this information can you take the final decision of whether you want to provide your data for participation in this lottery. So the idea is that you need the option to choose whether you want your data to be processed or not, and to know what the purpose of the data processing is, who may obtain your data. And so we still have to work on these various privacy policies and privacy clauses regarding video recording and other types of recording of various meetings, conferences, and so forth. The next set of principles is related to the purpose of our data processing. So this can be broken down into 4 sub-principles, and the first one that I'd like to note is if we want to begin processing data, then we have to understand what our purpose is. Why are we processing this data? Is there a problem that we will solve through this data processing? For example, a company cannot decide to set up a video surveillance system to spy on their employees and then just afterwards they'll decide what to do with these videos. So there has to be a problem to be solved. For example, employees are not abiding by work safety regulations. They are putting themselves in danger or so forth. And so this is the problem, that the solution for which is that we set up a video surveillance system. As a company, we also cannot require or request data with the idea that it might come in handy later on. For example, a company can ask a customer what their hobby is, what they like to do in their spare time. And if we ask the company why are they asking this to their customers, well, we thought that maybe sometime in the future we could implement a marketing campaign and use this data. But at the moment of obtaining these data, the company was not sure that they would actually implement such a campaign and whether the data would be used. So this is already a non-compliance with the rules of the GDPR. The next sub-principle is that if we have a purpose, then we still have to assess whether the processing is proportional to the purpose, whether the processing of the data will not have an adverse effect on the data subject. For example, a company cannot set up a video surveillance system at the desk of every single employee to survey their employees in the locker rooms and so forth. This is disproportionate surveillance, this is disproportionate data protection that is not proportionate with the purpose of the data processing. So proportionality is something that is very important. We can only ask for the data that we really do need. Common practice is that companies ask their employees to provide their declared or their official address, their actual address, their various contact information. In effect, as regards their address, the company doesn't actually need both of these addresses. It doesn't matter whether it's the official or the actual address of the employee. They just need the address at which the person can be reached. And as regards various types of contact information, if a company contacts their customers mostly by telephone, then you really have to think about whether you need to ask for the email addresses if you never use them. As regards proportionate processing of data, we also have to think about the technical aspects. When we work with the data, is it proportionate to our purpose? For example, if we send out emails to several recipients, we have to think about where we place the email addresses in the CC field or the BCC field, because depending on this, the recipients can or cannot see who else received the email. For example, I received an email from a hotel that was addressed to about 30 other people, and they thanked us for using their services, and gave this opportunity to use a promotional code, but I could see 30 other people that received this email, and perhaps some of them didn't want them other people to know that they had used the service. So another thing we have to think about is the purpose itself, because we cannot use the even publicly available data for different purposes than originally intended. We cannot use it for our marketing activities. Our personal ID that we provide to a company, for example, for the purposes of concluding a contract, this is only provided for the purpose of concluding that contract. It's not so that the company can send us a birthday card. Some people might, of course, be happy about it, but others may not be happy to receive a birthday card. Perhaps they don't like celebrating their birthday. You cannot use a person's personal ID code for any other purpose than originally intended, because we have to always abide by the initial purpose. And the last principle I wanted to mention here is the storage restrictions. We can store data only as long as the purpose is still in effect. In many cases, the storage periods have been set forth in legislation, but for example, for video surveillance records, each company can decide how long they keep these recordings, how long they keep their email correspondence, because emails are more for the purpose of communication rather than for these correspondence to be stored as long as any employee works for us. An example from our experience, we received a letter. We see the envelope here. It was a advertisement from an investigation agency saying that they have a very good experience, they are experts, and in place of putting a postage stamp on the envelope, they placed the photo of our director of our company on the envelope, and you see my picture there. But in any case, obviously we did not use the services of this company because they had breached the GDPR rules, they had breached intellectual property rules with just the setup of the envelope alone. So, in conclusion, the three main principles once again. So, precision, we have to be precise in regard to selection of the data that we process and the selection of the purpose for processing our data. So, for example, if an employee changes their last name, we do not necessarily have to change the person's last name in their employment contract, because at the time of concluding the contract, they had the last name that they had at that time, and nowadays they have a different last name, so obviously we can continue working with them. But, for example, of course, situations can differ. If a member of the board of our company leaves and asks for their data to be deleted, obviously we can delete this data from our website and so forth, but we cannot delete all of the information because there will always be a record of him having been the member of our company's board.
Well, these are measures. We have to have those legal measures, and we will have to have data security, but also technological solutions like managing right to access data, also how to protect our systems against attacks using firewalls and so on. We have to ensure confidentiality of the data, integrity of the data, so that the data are not changed without grounds. And we also should ensure that data do not disappear, that the data are not deleted without grounds, so that the data should be available to us. So, and also in accordance with the law on the protection of the data of natural persons, this is so. But the novelty is, if we have any kind of data protection infringements, if we send because of mistakenly we send an email to the wrong addressee, if our computer is lost, then it is that has data on it. We have to report to the state data protection inspectorate. That comes from the regulation. And a new principle that was introduced by the regulations, that's accountability principle. And this means that we, the companies, should be ready at any time, even when no one has suspicions that we are doing something unlawful, no one has complained about us. We have to be ready to prove in what way we comply, how we ensure this compliance. We have to document our processes. We have to prove that our laptops, for example, are coded, and when it has disappeared, and the way we obtain consent. So we really have to document it all, and we should be able to prove it all, even if no infringements have been identified. But we should introduce this accountability without exaggeration. In one company we saw they had a register of data processing. They described the processes, but added also the names of the employees and their personal ID numbers. We have to understand what we do, how we do that. In the register, we just describe the processes, because otherwise, by implementing wrongly this accountability principle, we are already infringing on the principles. So we should abide by those principles without exaggeration, protecting our reputation, protecting ourselves against huge fines, and also protecting our commercial secrets, as well as making all the processes more effective. Thank you. Thank you, and this is a token of our gratitude. Sanita Peterson, let's thank the speaker. It's quite interesting how they had stalked, but this postage stamp was not that bad. But actually, this service is offered by Latvian Post. If you want to send Christmas cards with your portrait on the stamp, you are very welcome to do so. Now, thinking about what Sanita just mentioned, that the date that we provide for all kinds of shop discount cards and so on, I remember the situation from real life. When I was a student, I had the possibility to, I ended up in a casino. And next year on my birthday in the morning, at 7:30 in the morning, the first person who congratulated me was the casino. Even my mom and dad had not phoned me, and at that point, I decided to send them an email that I wouldn't want to get any information from them. Now let's move outside the borders of Latvia. We have several guests here, guest speakers from abroad, and one of them is Vice Chairman of Deputy Chair of European Data Protection Board, Chairman of Commission for Personal Data Protection of Bulgaria, Mr. Ventislav Karadjov. Experience story. Ladies and gentlemen, those who need interpretation because the speaker will speak in English, you can get headsets at the entrance if anyone needs that.
Thank you very much. How I use that? Back at next, huh? Next.
Green is the forward.
Okay. Good. Well, thank you very much for the organizers for inviting me. I'm also in the data protection area for a while, already 7 years. Honestly, listening to my colleagues from Latvia, I would say I'm a very modest speaker, so I will be very short and precise on what I am presenting. First of all, it is 1 year on the implementation of the European data protection legislation on data processing. And I can share with you my knowledge, my experience on the data protection, but also what the European Data Protection Board And you know that this is the auspices of the data protection authorities in Europe, of the 28 data protection authorities, and also the European Data Protection Supervisor, including the European Commission, that are participating into the way how they consistently implement the new legislation, or is expecting from us as a data protection authority consistently to implement that legislation. First of all, why we are here? I'm here because I think that the future is not only what we dream, but what you make. And we have to know that this is a legislation that is for nowadays, but also for our future. And why so? Because I'm sure, and you as people that are working every day into the business, that without data you cannot do your business. You cannot provide the services, you cannot deliver the goods, because you have to know whom you are delivering and the address that you are delivering. You have to issue invoices, so the legislation obliging you to collect respective data in order to issue that invoice, and then after that you would be supervised by the financial services and etc. from the customs for the correct and complete processing of the data. So on behalf of the European Data Protection Board, we did have a lot of discussions in preparation of the implementation of the new rules. And why so? Because previously, before the data protection legislation, there were almost more than 20 different regimes of processing personal data. As I see, the regime in Bulgaria and in Latvia was more or less closer. You have had that notification, registration of controllers, and we also did have in our old legislation prior to the implementation of the GDPR, but the notification actually now does not exist in the new rules, regardless of the fact that the controllers have the same responsibilities and even more, and you have here been presented with the some of the new obligations like accountability that does not existed previously into the Directive 46, the predecessor law of the General Data Protection Regulation. Yes, but these rules, they required equal understanding and implementation at the European level, so that takes us a lot of preparation. And here I did show you how we do that, because it is not possible a single person to implement that new rules. In addition, we have to do the procedural rules of this new body, the European Data Protection Board, the memorandum of understanding between the board and the European Data Protection Supervisor, because the law says that the board is independent institution, but indeed its administration, the secretariat, is provided by another European institution, which is the European Data Protection Supervisor. And for those of you which are please excuse me because I don't know your experience in data protection, which don't know what the European Data Supervisor is. That is the European institution, like the Latvian Inspectorate, which is inspecting the way how the data is processed within the European institutions themselves and the offices and the organizations. For example, the European Commission, how the European Commission is implementing the personal data of the European citizens, how Europol is implementing that data, how the medical agency is implementing that data, etc., etc. So that institution, because it was already established and functioning, replaced the European Commission. The European Commission previously was the Secretariat of Working Party 29, which was the so-called think tank organization, the umbrella of the data protection authorities, before it was replaced by the European Data Protection Board with the new directive. So the difference between the Article 29 Working Party and the European Data Protection Board is only the fact that it is a public European body with with its own secretariat, and it also has some opportunity to to provide a consistent way of interpreting the rules, which consistent interpretation is obligatory for the data protection authorities when they have to implement the legislation. And here, this slide actually, in a more detail, explains what the board is and what the board is not. You can see its independency, legal personality, contributing to the consistent application of the GDPR, its day of establishment, and the composition also of the board. What the board is not, and it has to be clear that the board is not a separate supervisory authority, because a lot of people are thinking that the board can supervise the way how the general data protection implementation is implemented in Europe. No, the board is not supervising it, though the board is not investigating, and the board does not do enforcement. Those part of its capacity indirectly contributes to these activities, not to the investigation, but to the supervision of the consistent implementation, and to a certain extent to the enforcement, but indirectly through the data protection authorities, which on the spot in the member states are implementing these rules. But giving opinions and recommendations how to do that, the board indirectly forms the policies in Europe, of the consistent implementation. So, by promoting cooperation and effective exchange of information, best practices, and resolution of disputes between the different supervising authorities, the board indirectly complements the enforcement and strengthens the enforcement of the data protection authorities in the European countries. In addition, the GDPR gives an opportunity under Article 64 of the GDPR that each of the 28 member state authorities, including the chair of the board and the European Commission, to request that any matter of general application or producing effect in more than one member states be examined by the board with a view to obtain an opinion. This is why I'm telling you this, because it's quite important that the board, by its activities, can unify the way how the rights of the data subjects of us as individuals and the level of their protection in the member states is equal. For that reason, the board actually adopts different guidelines and opinions. Though they do not address you as a controllers or processors, they indirectly concern you, because these guidelines, they show the opinion of the board and of the member state data protection authorities on the way how they understand the law and how they are going to implement the law. And in fact, if you breach the law, they will implement these rules to you. And I will implement these rules to the controllers that are in Bulgaria, for example, and the processors. So indirectly, they are guidance also for you, because you have to know the practice of the data protection authorities in order to be able to comply with the rules and regulations in the European Union. Nowadays, they are more or less equal. And they're the same, not equal, they're the same in the member states. But you have to know that the General Data Protection Regulation also gave an opportunity to our member states for certain specific topics to adopt their local legislation on processing of personal data. Not only personal data for children of the age of the processing, but also for processing of, let's say, of personal identity number on certain cases in a member state. So there are some specifics on the processing of sensitive data that might be medical data or different type of sensitive data, including biometrics. So for that reason, the European Data Protection Board, you see, has issued different guidelines. Here we talk about derogations. These are the derogations concern they exclude the general processing of personal data for some reasons that you don't have to comply with the general rules for the processing. For example, let's say you want to transfer some of your personal data because you have a case law in the United States, but this data cannot be transferred by the company that has collected it from you for the purposes of the contract, even though you have not paid that contract. But based on these derogations, the company has a legitimate interest to defend herself, for you have not paid that for that money, and the company can transfer this data although you have not provided a consent for that. So these are type of derogations here that we have explained in what cases have to be implemented. The accreditation process for the companies. Also, we have heard about here about the territorial scope of the implementation, the codes of conduct when they and how they have to be implemented, the processing of personal information under Article 6. These are the legal grounds for the processing of the personal data. Also guidelines for video devices and CCTV surveillance. In addition to that, we have issued some statements on the use of personal data. In the course of political campaigns, you know, that was a big issue with Cambridge Analytica and the processing of millions of individuals' personal data. And we also issued a statement on the e-privacy regulation, which, as you are aware, last Friday at the EU countries in the Council rejected the latest version of the e-privacy legislation. And now the new European Commission must decide whether to keep these proposals, withdraw, or revamp them and provide some new suggestions for the member states to discuss and later on for the Parliament. And this issue also, let me see, the word I get. This article, this slide also explains what is the capacity of the European Data Protection Board. This is to advise also the European Commission on any issue related to the protection of personal data, such, for instance, the assessment of the adequacy level of data protection in third countries or, of course, in international organizations. And you know recently that there was a Japanese adequacy decision based on that capacity. The board and member states representative participate in the annual review of the Japanese adequacy decision, but also of the Privacy Shield instrument, which is the transfer instrument for European data for commercial purposes to the United States. As you know, why I'm telling you all this, as you know, as controllers, if you want to transfer the data to third countries, you have to comply with some rules. You have to have legal grounds for transferring of this data. And for that reason, one of the legal grounds is the adequacy decision. The other one is the standard contractual clauses. Or for the big companies is the binding corporate rules, which are internal rules within the corporation that are previously approved by the data protection authorities. And so for your information, in short, Europe has adequacy agreements with let's say Argentina, Canada, also with New Zealand, Switzerland, Uruguay, the United States of America, with the Faroe Islands, Isle of Man, Jersey, and Guernsey, which were former British islands nearby France. I would not continue with explaining too much about the role of the board and what we are doing here, but will tell you that the board, as I previously explained, issues certain opinions And there are a certain list of topics that are considered as having an impact in different member states. For that specific topics, which I've already have spoken to you, these are, for example, binding corporate rules for transferring of data, the codes of conduct that the company can adopt for the way how the data can be transparently and processed in compliance with the GDPR should be also arranged there. And for the certification and data protection impact assessment lists, the data protection authorities in the member states cannot themselves decide on. They have first to consult with the board and get the opinion of the board. For example, this data protection impact assessment list, this 36 opinion up there, these are activities that each national supervisory authority has to decide on the different processing activities which, for which because of their complexity and their sensitivity processing of the data, should be conducted an impact assessment by the controller. And based on that, the controller should undertake certain actions for the security of the data or for its compliant implementation with the rules. And the other specific capacity of the board is also to issue abiding decisions. This is the way how the board can also contribute to the consistent equal implementation of the regulation in the member states. And the abiding decision indeed concern the dispute resolution between a lead authority and concerned authorities. Because the GDPR compared to the Directive 46, as I mentioned, the predecessor of this legislation, allows a company that works in more than one member state to appoint one of the authorities where they have an establishment to be the authority that decides on on their own needs as a controller. And they do not have to consult with each member state where they have an actual provision of services or goods. For example, if a Latvian company is based here and this establishment takes a decision how to process the personal data, what type of data to be processed for the service collected, for example, and then disseminated and further processing for the certain services or delivery of goods, and they deliver in Bulgaria, and they are not gonna oblige to report to the Bulgarian Data Protection Authority if there is a violation. They have to report or they have to request the opinion of the Latvian Data Protection Authority. But if a Bulgarian citizen is not satisfied of the way of processing of his or her data, he can submit the complaint to our authority. What will happen then, we will look into this. I will show you later on, there is a database established by the European Data Protection Board. We will look there whether this authority has indicated, whether this controller has indicated that some of the 28 member state data protection authorities is a lead authority for him that decides on his control activities for processing personal data. And if we find out that he has indicated the Latvian Inspectorate, we will submit the complaint to the Latvian Inspectorate, but the Bulgarian authority will become a concerned authority, which means that the Latvian authority may request a joint inspection with us, or we can request a joint inspection with the Latvian authority, and the Latvian authority, as a lead authority, has to develop their statement on the case. But they have to consult it with the Bulgarian authority from their own, and we may object. If our objection is not considered reasonable, the Latvian authority, and here I will show you on the picture, the Latvian authority will be this lead authority. But the Bulgarian authority will be down there, the concerned one. And then if the Latvian authority propose some measures and we don't object, the lead authority, Latvian, adopts the measures and the case is over. But if there is an objection with the red over there, then the lead authority has to assess this objection. And if the objection is accepted, then the Latvian authority should update the draft, notify the concerned authority, and the case is also over. But if the Latvian authority, as a lead authority, does not consider the objection reasonable, and this objection of the Bulgarian authority, let's say for the proportionality of the sanction, or that the measures the Latvian authority proposed we consider that are not enough. For example, the Latvian authority proposed that they've changed their internal procedures only. But we think that the infringement actually is very serious. It concerns more than one Bulgarian citizen, and for that reason, we think that this authority, this controller should be sanctioned. And so they do not accept that objection. They said, no, 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 this is not for sanctioning, it's not proportional measure. Then they refuse the objection. And here, why I'm explaining you all that, comes this new body, the European Data Protection Board. This is the so-called consistency mechanism that ends with a binding decision of the board. And then this decision is obligatory for the lead authority and for the concerned authority. And the lead authority has to implement it and to defend it in court if there are complaints from the controller. So this is a completely new mechanism for consistency. Of course, into this obligatory decision, you have to know the board cannot decide on the proportionality of the sanction. It can decide, the Latvian authority will be the one that will finally decide how big the sanction will be, but they have to defend this as a proportional sanction because the board or the concerned authority may object and said this sanction is not proportional compared to the content of the infringement. So talking about that, I understand that for you as a small and medium enterprises that may not happen in your daily work of processing personal data, but you have to know that mechanism. And you have to know that this mechanism actually is providing consistency and equality of rights in all European Union. That means that the General Data Protection Regulation has envisaged such kind of opportunities. Of course, here there is a slide that I would like to talk about the opportunity of transferring personal data, and this is also the no deal or deal Brexit. You have to, in general, know what will happen in case of there is no deal. Maybe in the media here in Latvia is already a topic or a topic of discussion in the business circles, but in general talking, if there is a deal, there will be no problem, because if there is a deal, the UK will oblige itself for the next 2 years to comply with all of the European rules. And in this period, for 2 years, the European Commission will adopt an adequacy decision, which is a legal instrument for transferring of personal data compared with regard to Chapter 5 of the General Data Protection Regulation. That is the chapter and the rules regulating the transfer to third countries, because Great Britain will be considered a third country, third compared to the European Union countries that are members of the Union. And if that happens, after 2 years we will have an adequacy decision. It will be very easy for us to transfer personal data there for commercial purposes. I'm talking here only for commercial purposes, not for purposes of security and etc. But if there is no deal, then there will be significant number of problems for the transferring personal data. First of all, the legal grounds for transferring there will be only a standard contractual clauses or binding corporate rules that have been already adopted by the UK Information Commissioner Office. But if the companies that want to transfer data and they don't use these instruments, they don't have binding corporate rules, or they don't use the standard contractual clauses, these companies, they have to determine which processing activities will require transfers to the UK, because if they don't comply with the GDPR. To determine the pertinent instrument for the data transfer, that I have told you, the instruments are 3: adequacy decision, which will not exist, standard contractual clauses, which are the clauses, they are standard because they are adopted by the European Commission in a standard format, and these clauses, because of the adoption from the Commission and because the opinion of the European Data Protection Board has been given to them, are considered enough safeguard for the processing of personal data. But if in a contract that you are concluding with a UK company, for example, decide to change these standard contractual clauses in order to fit to the contract, they are not anymore standard contractual clauses. They become ad hoc clauses, which has to be further approved by the Data Protection Authority of Latvia. And you have to know that because you're doing international transfers, the Latvian Data Protection Authority in this case has to consult with the European Data Protection Board and ask for its opinion. But this process is not 1 month. It's about 13 weeks. And the board is not so flexible as the Latvian Data Protection Authority, because the board consists of the 28 member states. And how the board decides? The board has subgroups. The subgroups consist of experts from the data protection authorities of each of the 28 member states, which means that once a month they will collect to decide on certain issue. Until they come to the issue of approval of your changes in the standard contractual clauses, that may take 3 months. Yeah? And for this period, you shouldn't blame Latvian Data Protection Authority or the board, because these are the rules. There are other issues outstanding there. So you have to know that, and you have to, why I'm telling you that, because you have to pre-plan if that is your case, for example. So this is, of course, some of proposed activities that you have to do, including to upgrade the privacy policy in order to inform the data protection subjects. And one more slide about how I understand the compliance and of what it consists. These are some of the principles that we have already talked about. From my point of view, it starts first with the awareness phase, and then once being aware of the rules, how they are processed, and how the data should be processed, etc., it comes the accountability phase. This has been explained to you, but in general, you have to know that this is your responsibility for each action of processing of personal data, compared with your daily job as a company, as a state authority, etc. If you are obliged by law, or you collect data by contract, or collect data by, let's say, consent, or whatever of the 6 grounds that are in the GDPR established, you collect this data, you have to be accountable for the way how you are processing. You have to be responsible for your actions, and you have to be able to prove that you are processing this data in compliance with some of the principles of and the legal grounds set up into the regulation. And that's why we're talking about consistency. It is because it is not only for you, it is for all companies and public institutions in the European Union. They have also to implement these rules. And then we're talking about enforcement. Why I put it on the last place? It is because if some of the other principles doesn't work, then the Latvian Data Protection Authority should act. And to finish that presentation, I would say that the regulation is for all of us, and we, as you see, as the data protection authorities, should act in a consistent but in a joint matter as well sometimes. And that's why I think that no one is big enough alone to implement that, I would say, complex legislation and these complex obligations that are coming with the regulation. And with that, I want to thank you very much.
Thank you. And this is for you, for local authorities, the president. Thank you very much for your time. Dāmas un kungi, mums.
Ladies and gentlemen, we are very, very close to the coffee break and lunch break and coffee. But to conclude our discussions on the legal basis of the foundation, so we have now Lāsma Dilba from the Data State Inspectorate, and she will be speaking on legal basis of personal data processing. Hello, I'm happy to see so many of you here. I hope that our conference will be useful to you and will really help you as the seminars that we were organizing before, and will help you to be as compliant with the regulation as possible and to understand that the process can always be improved. You can always do better, but what you do and that you are doing this is very good. I would like to add one more thing today. All presentations that have been shown to us will be available on our homepage with the conference in the section of conference materials. So all the information that will be included in my presentation is more extensive than I will be speaking today, because you will have access to my presentation at any time. Now about the legal basis. The legal basis. I'm not the only one to mention this SKDS survey and the findings. And initially, this seemed quite fine. 80% of companies believe that they know quite well how to use the legal basis, and the employees know the legal basis, and they know the legal basis on which they are processing personal data. However, the other findings and other answers provided by the companies show that they would like to have additional information about those cases when they are allowed to transfer data to third parties and when they are allowed to process personal data without consent. So apparently these numbers and this percentage is not that excellent. Apparently those some among those 80% of companies are slightly mistaken, or they have mistaken perception of their knowledge. Actually, transferring of data is also data processing, and you need legal basis for data transfer as well. So it's not really important whether we speak about obtaining data or transferring the data. So the legal basis is required in all those cases. And there are 6, and each processing needs legal basis. Now, talking about legal basis and whether indeed there are some other legal bases apart from consent. Yes, there are 6 all in all. The majority of those present probably have attended seminars, and Agnes has been telling you, and you've read also in the regulation, we all know those legal grounds, and I will try to outline each of them in my presentation. Just to remind you that there are some other grounds apart from consent. I would like to note that no legal basis is in any way better or more correct or stronger or more necessary than others, or in some way more beneficial. All these grounds are equal. The one which is more appropriate for the particular case, of course, is the best to use. And it also depends upon the purpose of data processing and the relationship with the data subject that we have. In any case, when we are processing personal data, and when we look at the legal basis, the legal grounds that we are using, we should keep in mind all the personal data processing principles which Sanita explained to you already. All the legal basis cannot be isolated or separated from the principles. It is also linked with the restriction on purpose. Only when we have identified concrete and clear purpose, we will be able to understand which of the legal basis we can use. In addition to what has already been said, if we process personal data of special categories, we have to identify the legal basis referred to in Article 6 of the regulation and Article 9, additional conditions for processing these data. As I said, we have 6 legal bases. This is sort of the circle that we are offering and preparing. This was used also in the cycle of seminars and also in our recommendation on personal data processing. Now let's move on and examine each legal basis separately. The topic is indeed very extensive, and you know this as well. So it's impossible really to go in detail. But the most important things are here, and I will underscore what could really apply to SMEs. Consent. We all know that this should be free, concrete, clear, and it should be provided in a statement or action. Consent means that the person is offered actual control over the data. The persons are asked whether they even want to transfer the data for processing, and persons should know what will be done with the data. And only if the person has been sufficiently informed, only then the person has actual control. This has to be understood. This should be always informed consent, and the data subject should be provided as much information as possible. And here we come back to the principles, transparency and informing a person. A person should have sufficient information, otherwise this kind of consent won't be recognized as being adequate. Now, consent and conditions, I'm not going into detail about this, but here you see the most important things you have to pay attention to as controllers and processors in your businesses. But just now about some problems which we have identified as well, and also that we see there are some misunderstandings and questions also in society. First of all, those cases when the data subject and controller are not on equal terms, then you have to use this consent very cautiously. Examples, that could be an employer, a public institution. You should always look for legal basis that would really be compatible with the processing. For example, the employer might use consent to place an employee's birth date on the internet, so that other colleagues could congratulate them. And of course, the employee might be afraid to say no because they are not on equal terms. But in other activities, this consent could be quite risky because this could be recognized as not being adequate. Because you as entrepreneurs should always look at adequacy of data, and you should seek compliance, but you should always also look at the risks. What kind of risks could set in if you would act in one way or another, and if there is a risk that the consent could be recognized as not being adequate. So you would be processing personal data without legal basis, and so consequences could set in for you because sanctions could be applied by the inspectorate. Sometimes also we have the following problem. We see data processing consent is being requested, but the purpose is not precisely defined. We see that, for example, in institutions of education, we are going to use the data of your children for promoting our activities, but no specific information is being provided. In what way? In what way these data would be processed? They don't know in which kind of public portals or social networks the information would be provided, what kind of information, the scope of it. Also, consent form. It has to be, again, you have to be able to present it and prove it. And definitely, also a person should have the possibility to revoke the consent given. This was also revealed in this survey because not all companies ensure this possibility to revoke one's consent. Now, implementation of the agreement or enforcement of the agreement. This is a very this basis is used by SMEs. It's, of course, it's very good and adequate, but you have always really assess whether the data that are used for the contract and are required for the contract are really necessary for concluding it. For example, putting into a contract the information, as was mentioned before, about hobbies, for example. If you have a contract on delivering goods, additional information on your on your hobbies is not really necessary. And also, if you are delivering the goods by post, but you are also requesting an email, these are two different purposes, two different types of processing, and including email in the contract, again, will not be adequate, and probably this legal basis won't be adequate for processing personal data.
So, as we know, the enforcement of a contract has to either be based on an existing contract or the data processing is necessary to conclude a contract. Excuse me for my phone going off. So the legal requirement applies both to the public and private sectors. And the legal basis in this requirement is set forth in legal acts. So not only in the law, but also in Cabinet of Ministers regulations, there could be other binding legal acts providing this legal basis. The protection of vital interest is something that we won't delve into right now because in regard to SMEs and the data processing that you do, this would be a very rare occurrence. As regards public interest, here I'd like to highlight that public interest are those arising out of the legal obligation, and this could entail two different situations. First of all, that either of the subjects has the legal obligation placed upon them by law that they have to provide this processing based on legal requirements, and the second type of situation that this agency that has this obligation to disclose information to a subject that doesn't have such an authorization, but the subject does perform data processing in the public interest. Now, the last but certainly not least is the legal basis in terms of legal legitimate interest. This is one of the more complex legal bases in terms of how to assess it, because the controller has to assess the proportionality of their interest to the interest of the data subject. And if such an assessment is not performed, then this legal basis is not adequate for data processing. This legal basis cannot be used by public authorities for data processing, and in order to use this legal basis, you have to perform this assessment and enter in framework of accountability, also document it and update it if necessary, and be able to demonstrate this assessment of the legitimate interest to the authorities if necessary. Now, the cases that you can use this legal basis are listed on this slide here. Most of you probably already know about them. Then the last issue I'd like to raise is these balancing tests. The European Commission has stated that there need to be 3 cumulative requirements. So first of all, the existence of legal interest or legitimate interest, and this interest cannot prevail over the rights and freedoms of the data subject. Now, a broader test, or a broader assessment, is provided by the working group under Article 29. At the moment, however, we don't have enough time to go into detail about this, but in any case, I'd urge you to study this, the opinion of that working group. Also, you have links to it on my presentation. So I hope that you have gained a better understanding of the legal basis, and I'll answer any questions if they arise. Lasma, do stay on the stage, and I will now ask the other speakers to join us on stage for a brief panel discussion. So, Ms. Agnes Babovica, Lauris Dinabergs, Mr. Venslav Karadziov, and Lasma, and Santa Peterson as well. Please join us here. So thank you all for submitting your questions on slido.com. We have a lot of questions that have been sent in. We'll try to go through them really quickly. I'm sure we won't get a chance to go through all of them, but I've tried to sort of structure them. The members of our panel, the one who wants to or knows the answer right away, so just raise your hand and jump right in. So first of all, prior to the beginning of the conference, there was an announcement on the screen saying that the conference will be filmed and recorded. But if I don't want to be filmed or recorded, how do I tell you that I don't give my consent for this? Well, yes, we did indeed have this announcement on our screen. So what to do if you don't want to be photographed or filmed? So let's make sure the microphones are working. Well, I am not a controller regarding this data processing, but my opinion is that not always do we need someone's consent, and not always do we have a legal basis to require consent. So in this case, it's probably not that we require consent. The legal basis is different. So we don't require consent as such. The legal basis is provided in a different manner. Next question. How can we make sure that a state body requesting information does indeed need it? How much information we can provide? Can a controller refuse to provide information to a state institution? Yes, it's a very good question. Thank you. I think that in this case, one of our speakers already mentioned the need to assess this request. We have to think about two things. First of all, we have to assess whether the legal basis that is noted in the justification of the request submitted by the state body is adequate. So, for example, if there is a grants regulation saying that they need the name and surname and personal ID of a candidate, but then they also require their address, their legal address, and their bank account number. So then if the legal act upon which the agency is working on does not require this information, then the request is not adequate. But if the agency has, for example, a case at their disposal, or they are investigating a certain person, well, this is something that you can't always know, so you sort of also have to use your common sense in these situations.
Well, first of all, I think that here is very correctly said. If that is the case, you have to look for the competency of the agency. What this agency is doing and it is vested by law to do, because the public agencies, they have to have enough information to objectively decide on a certain case. And for that reasons, they have the competency to request that information from physical persons, but also from other public institutions. And the other public institutions are normally obliged in 1 month period to provide that information so that the agency can decide on a certain case. But if they request information outside of the scope of their competencies, then obviously this is not an information that is proportionate or needed for their specific decision-making process. This is what I can say for that case.
Mm-hmm. Thank you. Yeah. Lauri, you?
Lauris, do you have a comment? Well, to summarize perhaps what my colleagues already said, the regulation states that state bodies have two legal bases, so either specifically implied in legislation or for the purposes of public interest. So in the case of legal capacity or legal competence, this will already be stated in the relevant legal act. For public interest, however, of course, we have to look on a case-by-case basis. Next question is about money. What are the estimates on the amount of funding and human resources necessary for data processing activities for 1 year for an SME? Well, I don't have such estimates at my disposal. These resources will be dependent on the profile of each company, because we can have an SME that works with a lot of data, so for them the investment will have to be proportionately large. However, we can also have an entrepreneur that works with the data only in terms of complying with the basic legal requirements, for example, for accounting purposes. So their investments in data protection will not need to be that large. So there's a lot of elements that need to be considered in determining the amount of investment needed.
To have in mind that the GDPR says that the controllers or processors should adopt appropriate measures. Appropriate measures are considered as a terminology that it is appropriate for the specific activity of the controller based on its resources and financial, human and financial resources, I would say. Because if it is a big company and it has significant human and financial resources, it would be expected from them to have a more significant investment into the way how they process personal data. Plus, they are going to process a big variety of personal data and in big quantities because of their big business. For small medium enterprises that consist, for example, 10, 15 people or 5 people, it is not expected that they are going to collect and process big amounts of data. And you have to have in mind that the associations that you belong to
are supposed also to develop different code of conducts to submit them to the Data Protection Authority for their approval. And into this code of conducts, there should be certain rules for processing personal data that you can easily adopt and implement into your daily business, and that will actually diminish your costs for the implementation of the regulation. That should be the rule.
Thank you. Agnes, jūs komentārs bija par šo?
Agnes, did you have a comment? Well, my colleague already said what I wanted to say. I'd just like to add that this is not something that you just set up one file today, you invest an X amount of money, and that's it, we're done. It's a shift in the corporate culture. It's educating your employees. We are beginning a process. We train our employees, explain the whole process, and it's a living process. It's not something that you can state in just a specific amount of money. It's something that transforms and develops. But could you sketch out sort of the approximate prices on the market? Well, this is a very sensitive issue that I wouldn't want to delve into. I'd like to come back to the survey where entrepreneurs had already said about, answered about the investments that they've done. And I think it was about, the average was about 500 euros that companies have invested in regards to the implementation of the GDPR.
Costs may be, let's say, very low, depend on what type of business you're doing. So that's why you have to know what type of, because the consultant is going to do the same. You have to see what type of business you are doing. And if you are providing services, you have to know what minimum data you need in order to provide this service. Whether you need the personal name, whether you need the identification number, or you need the address of this person. You have to know the minimum data. And once you know this minimum data, based on your financial resources, you may undertake different actions because they can be considered appropriate for you. If you are a company of 3 people, obviously you don't need a special, let's say, security measures with a card to enter the office and to go out of the office. You can put all this data in a file, in a, let's say, in a metal, how it's called, wardrobe, and you can lock it. And this is appropriate measure because it's 3 of you there. Yeah, and you can appoint in the internal rules one of you that will be responsible for keep this data there locked and for providing this data, for example, to the transportation company that has to deliver certain good, or to make a phone call to the client and inform him about certain activities of your business. So this does not cost a lot of money because anyway you are paying to these people to do this job. You just have to instruct them. And this depends on what data you are doing. You have to do inventory of the data that you are processing compared to your business, to your services, or to the deliveries that you are doing. And whom you are using as a, let's say, in your business to, let's say, to complete your services, whether you are using a transportation company, and then you have to decide what type of data you're going to give to this transportation company. And you have to have a contract with them, and in the contract you are going to say that they have to comply with that and that rules for that and that reasons. In this way you are securing yourself if someone wants to submit a complaint later on. So it's not a big deal. Huh?
Paldies, thank you. Paturpināt tālāk, vai...
Thank you. Moving on, does the regulation not set a disproportionate administrative burden on the controller in approving various documents and thus taking them away from their primary functions? Well, in this case, I'd like to come back to the corporate culture. Our experience so far shows that we focus on the paper, on the administrative side, on the bureaucracy. So the legal side is important, but we also have the technological aspects and the administrative aspects. So if we approach this only as a bureaucratic element, then we don't approach it correctly. If we approach it as a way to protect our business, then it's no longer bureaucracy. If this is the foundation for our choice of technologies, our choice of procedures. So on May 25th, everyone had a huge deluge of privacy policy updates coming into their emails and whatnot. But the idea here is that this is not just a bureaucratic piece of paper. It's something that needs to be understood. Our employees need to understand what's written on this piece of paper. And as I already explained, from my personal experience, we drafted the internal procedure for using our access cards in our agency. We put a lot of work in it. We involved a lot of departments. Then we had training to explain to our employees what the data protection actually means. And what we had a mechanism in place that there's this closed off area that is accessible only to the employees with their access chips. And if there's someone that doesn't belong in this area, then they have to be removed. But then when we went to this training session, this door to the locked area was just open and there was a chair placed to keep the door open. So what was the use of this whole mechanism? So if we just set something out on paper but then don't actually implement it in practice, then it's completely useless. Thank you. So in one of the presentations, deceased people were mentioned. So the regulation does not apply to the deceased, but what is the procedure in situations when deceased person's data affects living relatives or living kin? Well, data protection is basically anything that is connected to a living natural person. So if the data regarding a deceased person affects a living natural person, then this will be within the scope of the GDPR. So the best and worst case example, as always, is, for example, hereditary diseases. So if we know that a deceased person had a hereditary disease, then this is data that is also applicable to their living relatives and it is part of their personal data. And as regards condolences, I'd say that this isn't really corporate information. This would not be within the scope. It would be household information. Well, but how about newspapers? For example, we have information posted in the newspaper that so-and-so has passed away. Well, what Agnes already said, that the data, the regulation does not apply to information processed for household purposes. So in this case, condolences would not be within the scope of the GDPR. So the next question is about business cards. How should these be stored? Because they contain personal data. Well, the existence of a business card as such does not mean that a company has the right to use this data. We have to record how we've obtained this business card, and only then can we understand whether we can use it in our legitimate interest. Because if we met this person at a conference such as today, and we exchanged our cards with the idea of that we will provide each other with information and communicate further about services of interest to us. But the fact that we just hold someone's business card does not mean that we can use it for marketing purposes or such. So business cards, this is not automated data processing. This is a sort of filing system of sorts that will come under the scope of the regulation in certain situations. Well, as long as we've placed the business cards within a filing system. Do you have any ideas of what that would look like?
It's very important here for what purposes you collect the data, including the data from the business cards. Because if you're a marketing company and you are invited here on a marketing event, my purpose is to do marketing. So I would collect these business cards to continue doing my business. And so from that perspective, you have to know that I will target you with different marketing products. So it is very important if, for example, it is a business event for industrial, let's say, demonstration of industrial products, and you're collecting here people that are engineers for the development of certain specific type of technology, and then all of a sudden they get information about best sales of, let's say, washing machines or TVs or washing powder, whatever. This is use of their personal data not in compliance with the GDPR, because this is marketing for different purposes of what they have given their business cards. This is what we're talking. But if you come to an event where a marketing company which represents, let's say, 20 different companies from different businesses, and they are in front of you on the screen, and they already familiarize you with what they're doing, what products they propose on the market, or they intend to propose on the market, or what products worldwide they propose, and some of them may come on the market if there is an interest locally, let's say in Latvia, then you have to expect that they will use your information because you are invited there for that purpose.
Paldies, thank you.
Thank you. Some additional questions. How should the processor of data do if the data subject immediately turns to him with a request to amend data or to raise data, but not to the controller, if there's one stage in missing, so to say? Well, actually, the answer should be or found in the contract. It should be, this provision should be included in the contract. A quite interesting question. Speaking about mass media, if a mass media is republishing a picture of a public person which is republished from social media, is it a violation? Well, with respect to mass media, you have to understand that the same principles do not apply to mass media as to companies. Press, the freedom of speech, other restrictions, other terms and conditions. So in some cases, mass media could have more rights. They could use publicly accessible information if this contributes and gives some information which is valuable for society.
Well, the issue with the mass media, you have to know it's controversial. First of all, you have to know that the right to access information or freedom of speech is not an absolute right, and also is not an absolute right, the right for privacy. These rights, the GDPR says they have to be balanced, which means that the mass media, based on the case, should do an assessment whether this information is related with their case and it is proportional. These principles cannot be, overtaken by the mass media. Because if there is a complaint, the mass media should be able to prove that they've already done this assessment. So there are a lot of cases in the Court for Human Rights in Strasbourg which says that the information has to be somehow related to the public image of the person or for the job of the person, and etc. It cannot be, let's say, information that has nothing related with this person or information related to his kids, not related with his activity as a public figure, let's say a decision maker. So that information will be considered excessive. So the mass media also should have that in mind. Yes, they can take a picture, and if this picture is somehow related to the decision-making process of this person, they can prove that this person has or is doing a subjective decision making, or is corrupt, or etc. For example, they may picture a very luxurious house and take it, or this person has published something from his house in the, let's say, Facebook, and they can take that picture and they can show that this person doesn't earn this money in order to have that luxury house. And obviously, they are suspicious of the decision-making process that he's doing. But there are some rules, and the mass media should also comply with these rules.
Paldies. Yeah, well, easily.
Very briefly, well, before the regulation, historically, we had an example where our court decided on this interaction between the freedom of speech and the privacy of a person. The story was as follows. There was a project, the fund and seminars were organized, but the mass media, in order to illustrate this project, they had taken a photo of participants in the informal part of it, where they had gone in sauna and used this picture to illustrate the project. And this was a training project. And our court historically said that this was not reasonable and it was not adequate for the particular situation. The famous conversations in sauna, no, that was before that story. That was a joke.
Yeah, but not team building.
And now, one before the last. For how long and what kind of data can be stored about the previous customer, client, both natural and legal person? Again, you have to look at the regulation in legal acts. It could also be linked to anti-money laundering laws as well. And yeah, but this law, but also you should look at the type and kind of services that the client used. If I'm not mistaken, then with respect to deposits, this information had to be stored for quite some time, like 60 periods. So actually, you have to look at each document and each piece of information, and banks have to analyze also this in the context of anti-money laundering. Well, banks, medicine, these are fields that are quite strictly regulated with some kind of internal regulations. And in order to understand, as Agnes has said, what kind of norms are applicable, you should really look at each case.
A little bit. Very short.
Short comment.
Yeah.
Okay.
It is difficult to say how long you have the opportunity to preserve this data. First of all, clients normally want this data to be deleted. They said, oh, I'm not a client of this company for more than 3 years, so I want this data to be deleted. But for you as companies that are processing this data, as controllers, for example, what you have to do, you have to, very correctly, my colleague said, you have to do this thing. You make a column with what you are doing. Services, delivery of goods, whatever. Then you put another column, what data you need. And then you put the third column, what are the legal grounds for processing of this data. Once you know the legal grounds for processing the data, you will know the legislation more or less. In the legislation, in most of the cases, it's written specific data that you've collected, how long you have to keep it for investigation purposes, for supervision purposes, etc., of different institutions. For example, if you issue an invoice of this person, you have to keep the data as set 60 or 50 years. And that is set in the law, in the accountancy law, for example. So on that basis, you have the right to keep this data for about 50 years, for example. And this person may request to be deleted his data, but you would be prepared to answer him that you are obliged according to that and that law to keep this data for this certain period of time. But once you put all these columns, for example, and you don't have a legal grounds, but still you have collected data based on previous grounds, for example, then you have to yourself decide how long you need this data for your services. If you don't need this data for more than 1 or 2 years, 3 years, 5 years, and there are no other obligations according to legislation, then it is you as a controller to decide. And you have to delete it based on that decision taken by you. And this is the difference in a way how you have to be, in order to be accountable. Because if you don't have other legal backgrounds, you may collect this data and keep it for a reasonable period of time. But you have to prove that this is a reasonable period of time. This is part of your accountability as a controller.
Thank you. And the last question also goes, Mr. Krajov, to you. I will do it in Latvian.
The European in what way does the European Data Protection Board involves businesses in drafting the guidelines and documents? To what extent are you taking into account the practical experience of companies in drafting the documents?
Yeah, we always do. It is obligatory part of our public hearing. First of all, I did try to explain you, the documents are normally developed by the subgroups. The subgroups are groups of experts from the various data protection authorities. Each authority appoints an experienced person there, and they debate on certain issues. They normally have one of the authorities that is lead on this topic, and they have 1 or 2 reporters there that present their experience or the international experience in this topic. Once they get to a certain solution on the issue, they propose a report. And this report is reported in the plenary, and we take a decision in general that we agree with this approach, and then we put it on a public hearing, a public debate with the business. Then there is a certain period of time, at least 1 month, that we debate with the business. We get their questions. There are meetings with the business, and we incorporate or disagree with their proposals, so we can revamp we can change our initial opinion about certain way of thinking on the implementation of the regulation based on some, of course, logical objections on the side of the business. And after that public hearing with the business, we adopt the final opinions or guidelines of the board. So in any case, any opinion or any guideline, because the opinions are a little bit different, any guideline that we adopt, it is consulted with the business.
Paldies. Paldies mūsu īsās paneļa diskusijas.
Thank you for the participation of this panel discussion or Q&A session. And thank you to all who asked questions. I do apologize that I did not manage to ask all the questions, but we are going to have another Q&A part. And now we have a short lunch break, and I will ask you to return back to your seats within an approximately hour.